Good day everyone, my name is Josemary Ambe Sanchez, and in this video, I'm gonna tackle about my part in Chapter 4, Extinguishment of Obligations, which is the subsection 3, Tender of Payment and Consignation. In subsection 3, Tender of Payment and Consignation, we have an article 1256. In this article, it states that if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Before I explain what is the meaning of the article, let me first explain what are the meanings of our topic in each word, which is the tender of payment and consignation. First, we have here tender. Tender in law means offering to pay or do something as agreed upon or as promised. Second is payment. It means giving money for something, while consignation means handing over goods to someone to sell or to keep. Now that we understood each words of our topic, let's proceed to the article. The article 1256 tells us that if someone tries to pay a debt, but the person they owe, which is the creditor, unfairly refuses to accept the payment, the person who owes, which is the debtor, can first put the money or goods in a safe place, and that is our consignation. Second is to be freed from owing a debt. It means that you no longer have to pay for it or your debt is cancelled. And that is the meaning of our article, which is the article 1256. Here is a question. In what cases does consignation alone produce the same effect? Well, these are the following cases if consignation alone produce the same effect. First, when the creditor is absent or unknown or does not appear at the place of payment. In this statement, it means that if the person you owe money to, creditor, is not around, can't be found and doesn't show up to collect the payment, you can still pay by putting the money in a safe place, and that is our consignation, and it's considered paid. Second, when he is incapacitated to receive the payment at the time it is due. In this statement, it means that if the person you owe money to, creditor, is unavailable or unable to receive payment when it's due, you can put the money in a safe place and it's considered paid. Third, when without just cause, he refuses to give a receipt. Well, in this statement, it means that if the person you owe money, which is the creditor, unfairly refuses to give you a receipt for the payment, you can put the money in a safe place and it's considered paid. 4. When two or more persons claim the same right to collect, it means that if two or more people claim they should get the payment, you can put the money in a safe place and it's considered paid. To avoid any confusion, multiple people want the payment. To avoid trouble, you put the money in a safe place and it's done. Last but not the least, when the title of the obligation has been lost. If you lost the paper that proves you owe money, putting the money in a safe place still counts as paying. And that are the cases if consignation alone produce the same effect. And now, let's move on to what is tender of payment. In the book, tender of payment is the definitive act of offering the creditor what is due him or her, together with the demand that the creditor accept the same. When a creditor refuses the debtor's tender of payment, the law allows the consignation of the thing or the sum due. Tender and consignation have the effect of payment, as by consignation, the thing due is deposited and placed at the disposal of the judicial authorities for the creditor to collect. More important, there must be a fusion of intent, ability, and capability to make good such offer, which must be absolute and must cover the amount due. In this tender of payment, it means that offering the tender the exact amount they owed and asking them to accept it. If the creditor refuses, you can put the money in a safe place for them to collect later. To make a tender, you must really intend to pay, have the ability to pay, and offer the exact amount owed. By doing this, you've essentially made a payment even if the creditor doesn't accept it. Tender of payment means offering the creditor the exact amount they owed. and asking them to accept it, and if the creditor refuses, you can put the money in a safe place for them to collect later. To make a tender, you must really intend to pay and have the ability to pay and offer the exact amount owed. By doing this, you've essentially made the payment even if the creditor doesn't accept it. Well settled is the rule that tender of payment must be accompanied by consignation in order that the effects of payment may be produced. Next is consignation. In the book, consignation means that it must be borne in mind, however, that a mere tender of payment is not enough to extinguish an obligation. The Supreme Court distinguished consignation from tender of payment and reiterated the rule that both must be validly done in order to effect the extinguishment of the obligation. Thus, consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. In simple words, consignation means a simple offer to pay. Tender of payment is not enough to cancel a debt. Both offering to pay and putting the money in a safe place, and that is our consignation, which is putting the money in a safe place, must be done to officially cancel the debt. Consignation is when you put the money you owe into a safe place, like a court, because the person you owe money to won't accept it. Usually, you must first offer to pay them directly before doing this. And that is the meaning of our consignation. According to the book, tender is the antecedent of consignation. That is an act preparatory to the consignation, which is the deter, desires, or seeks to obtain. In simple words, tender is like a first step. You offer to pay the debt, which is tender, and if that's not accepted, then you put the money in a safe place, and that is consignation, because tender comes before consignation. Tender of payment may be extrajudicial, while consignation is necessarily judicial, and the priority of the first is the attempt to make a private settlement before proceeding to the solemnities of consignation. In simple words, tender of payment is like a private offer to pay, which can be done outside of court. Consignation is a more formal process that involves putting the money in a safe place through the court. The idea is to try to settle things privately first, that is tender, before going to court, consignation. Tender and consignation were validly made, produces the effect of payment and extinguishes that obligation. Which means when you make a valid tender, which is you offer to pay, and consignation, putting the money in a safe place, it's like you've actually paid the debt. The debt is then considered fully paid and is cancelled. As cited earlier, consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. It is of no moment if the refusal to accept payment be reasonable or not. Indeed, consignation is the remedy for an unjust refusal to accept payment. The first paragraph of Article 1256 of the Civil Code precisely provides that if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. It simply means that consignation is a way to pay a debt by depositing the money with the court when the creditor, the person you owe money to, won't accept payment. You must offer to pay them directly, which is tender of payment. It doesn't matter if the creditor has a good reason or not for refusing payment, but if they refuse, you can use consignation to pay the debt. Because according to the law, if you offer to pay someone and they refuse without a good reason, you can pay the debt by depositing the money with the court. This releases you from responsibility for the debt. And think of consignation like a safety net. It protects you from being held responsible for a debt if the creditor unfairly refuses payment. We have here an example. Let's say James owes Mark 100,000 pesos with 12 interest per annum. At maturity date, James offered to pay. However, Mark refused to receive the payment. What is the remedy of James? Because to him, payment of interest is already burdensome. James' remedy is to deposit the sum of money with the court so as to extinguish his obligation. And now let's explain the example. James owes Mark 100,000 pesos with a 12% interest rate per year. When it's time to pay, James offers the money, but Mark refuses to take it. James doesn't want to keep paying interest, which is adding up and becoming a burden. To solve this problem, James can deposit the 100,000 pesos with the court. This is called consignation. By doing this, James is showing that he's willing and able to pay the debt, but Mark won't accept it. Once James deposits the money with the court, his obligation to pay the debt is considered fulfilled. He won't have to pay any more interest and he'll be released from the debt. This way, James can avoid paying more interest than he already owes. And that is our explanation in that example of consignation. Next, here are the requisites of consignation. This refers to the necessary conditions or requirements that must be met in order for consignation to be valid. Moreover, in order that consignation may be effective, the debtor must show that first, there was a debt due. It means that someone owed money and it was time to pay. Second, the consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it, or because he or she was absent or incapacitated, or because several persons claimed to be entitled to receive the amount due, or because the title to the obligation had been lost. It means that consignation is done when the creditor refuses payment, is absent or incapacitated, or when multiple people claim to be owed the money, or if the document proving the debt is lost. This allows the debtor to fulfill their obligation by depositing the payment with the court, ensuring they meet their responsibility despite the challenging circumstances. Number 3. Previous notice of the consignation had been given to the person interested in the performance of the obligation. Before making a consignation, which is depositing payment with the court, the person making the payment must notify the creditor, the person they owe money to, about the upcoming consignation so they're aware of the payment being made. 4. The amount due was placed at the disposal of the court. It means that the money owed was given to the court for the creditor to collect. And last is that after consignation had been made, the person interested was notified of the action. It means that after the payment was made to the court, the person owed the money was informed about it. Note, failure in any of these requirements is enough ground to render a consignation ineffective. It means that if any of the necessary steps for consignation are missed or done incorrectly, the consignation will not be valid. Let's move on to mandatory construction of the codal provisions on consignation. These are the rules about consignation must be followed exactly as written. The Supreme Court ruled that the codal provisions of the Civil Code dealing with consignation, Articles 1252 to 1261, should be accorded a mandatory construction. It means that the Supreme Court decided that the rules about consignation in the Civil Code must be followed strictly and exactly as written. This means that these rules cannot be ignored or changed and must be applied in every situation. We do not agree with the question decision. We hold that the essential requisites of a valid consignation must be complied with fully and strictly in accordance with the law. Articles 1256 to 1261, New Civil Code, that these articles must be accorded a mandatory construction in clearly evident and plain from the very language of the codal provisions themselves, which require absolute compliance with the essential requisites therein provided. Substantial compliance is not enough, for that would render only directory construction to the law. The use of the word shall and must, which are imperative, operating to impose a duty which may be enforced, positively indicated that all the essential requisites of a valid consignation must be complied with. The Civil Code articles expressly and explicitly direct what must be essentially done in order that consignation shall be valid and effectual. It means that we disagree with the previous decision. We believe that to make a consignation valid, all the necessary requirements must be followed exactly as stated in the law, Articles 1256 to 1261, the new Civil Code. The law requires absolute compliance, meaning every single requirement must be met. Just following most of the requirements, substantial compliance is not enough. The words shall and must in the law indicate that these requirements are not optional, but mandatory. The law clearly states what needs to be done for a consignation to be valid. Likewise, the Supreme Court enumerated the requirements prescribed by law for a valid consignation. One of the given requirements is that after consignation had been made, the person interested was notified thereof in Article 1178 Civil Code. The reason for such a requirement was given by the Supreme Court. In this statement, it means that the Supreme Court listed the requirements for a valid consignation. One requirement is that after making the consignation, the person who is owed the money must be notified. The reason for this requirement is to inform the person that the payment has been made so they are aware of it. It stated that there should be notice to the creditor prior and after consignation as required by the Civil Code. The reason for this is obvious, namely to enable the creditor to withdraw the goods or money deposited. Indeed, it would be unjust to make him suffer the risk for any deterioration, depreciation, or loss of such goods or money by reason of lack of knowledge of the consignation. In this statement, it means that the law requires that the person owed money, which is the creditor, be notified before and after the consignation. This is so the creditor knows about the payment and can claim it. If they're not informed, they might lose money if the goods or money deposited are damaged, lost, or decreased in value. It's only fair that they're notified to avoid any unnecessary loss. Next is the complaint for consignation. A complaint for consignation is a court filing to prove payment of a debt was attempted but rejected by the creditor. In one case, the Supreme Court held to wit. The records reveal that Respondent Corporation did not file any formal complaint for consignation but merely deposited the check with the clerk of court. A formal complaint must be commenced with the trial court to provide the proper venue for determination if there is a valid tender of payment. It means that the Supreme Court said that just depositing a check with the court is not enough. To prove payment, a formal complaint or a legal document must be filed with the court. This is necessary so the court can decide if the payment was made correctly and voluntarily. Just depositing the check is not enough to prove that the payment was valid or accepted. And now, let's move on to rationale for consignation. The rationale for consignation is the reason or purpose behind making a consignation. In simple terms, consignation is done to prove payment was made, show that the debtor tried to pay, protect the debtor for further claims, and allow the court to decide if the payment was valid. It's a way to resolve disputes over payment and ensure fairness. The rationale for consignation is to avoid the performance of an obligation becoming more onerous to debtor by reason of causes not imputable to him. In this statement, it means that the main reason for consignation is to protect the person who owes money, which is the debtor, from unfair situations. This means that if something beyond the debtor's control makes it harder for them to fulfill their obligation, like paying a debt, consignation helps to prevent extra difficulties or costs for the debtor. And it also ensures that the debtor isn't unfairly penalized and allow the debtor to fulfill their obligation in a fair and reasonable way. The purpose of consignation is to prevent the debtor's obligation from becoming harder to fulfill due to circumstances beyond their control. We have here a problem, and let us answer this after we state what is the problem. M obtained a commercial loan in the amount of 700,000 pesos from T. Lending Corporation. The loan was evidenced by a promissory note dated December 11, 1987, and secured by a real estate mortgage executed on December 15, 1987 over the spouses M and N's land and 4-story building. In this statement, M borrowed 700,000 pesos from T. Lending Corporation for business purposes. To ensure the loan is paid back, M signed a promissory note, a written promise to pay on December 11, 1987. M and their spouse N used their land and 4-story building as security for the loan by signing a real estate mortgage on December 15, 1987. To be able to pay the loan in favor of T Corporation, the spouses M and N applied for a loan with P Bank and offered as collateral the same properties they previously mortgaged to T Corporation. P Bank approved the loan application for 1.3 million pesos through a letter dated July 8, 1989. The release of the amount, however, was conditioned of the cancellation of the mortgage in favor of T Corporation. Now, in this statement, it means that M and N wanted to pay back their loan to T Corporation. To do this, they applied for a new loan with P Bank for 1.3 million pesos and offered the same land and 4-story building already mortgaged to T Corporation as collateral. P Bank approved the loan, but with one condition. Before releasing the 1.3 million pesos, the mortgage with T Corporation must be cancelled. This means that M and N need to settle their debt with T Corporation first before they can get the new loan from P Bank. Next, on July 20, 1989, M executed a special power of attorney authorizing S, T Corp's president, to collect the proceeds of his P Bank loan. S again went to the bank to inquire about the proceeds of the loan. This time, the bank's officers confirmed that the existence of the 1.3 million loan pesos, but they required S to first sign a deed of release or cancellation of the mortgage before they could release the proceeds of the loan to her. Outraged that the spouses M and N used the properties mortgaged to T Corporation as collateral for the P Bank loan, S refused to sign the deed and did not collect the 1.3 million loan proceeds. In this statement, it means that on July 20, 1989, M gave S, the T Corp's president, the power to collect the 1.3 million pesos loan from P Bank. S went to the bank and was told that the loan existed, but S had to sign a document concealing the mortgage on the properties which was already mortgaged to the T Corp. S was angry because M and N had used the same properties as collateral for the new loan. So S refused to sign the document and didn't collect the loan money. In continuation, as T Corporation loan was already due, S instituted foreclosure proceedings against the spouses M and N on July 24, 1989. It means that since M and N didn't pay their loan to T Corp on time, S, the T Corp's president, started the process to take ownership of the properties used as collateral. This process is called foreclosure. S began the foreclosure proceedings against M and N on July 24, 1989. To prevent the foreclosure of their properties, the spouses filed an action for specific performance and damages. They claimed that the assignment of the proceeds of P Bank loan amounted to the payment of the T Corporation loan. It means that to stop T Corp from taking their properties, M and N went to court and filed a case. They argued that by signing the P Bank loan proceeds to T Corporation, they had essentially paid their debt to T Corp, but T Corp shouldn't be allowed to foreclose on their properties. M and N wanted the court to order the T Corporation to accept the assigned loan proceeds as payment and stop the foreclosure process, and also award them damages or compensation for any harm caused. And we have here a question. Is refusal without just equivalent to payment? This question means that if someone refuses to accept payment or fulfillment of an obligation without a valid reason, does the refusal automatically count as if the payment had been made? The answer on our problem is that while S' refusal was unjustified and unreasonable, M's position is that this refusal had the effect of payment that extinguished his obligation to T Corp. Because Article 1256 is clear and unequivocal on this point when it provides that Article 1256, if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. It means that if a creditor, the person owed money, and fairly refuses to accept payment from the debtor, the person who owes money, the debtor can still be considered free from debt by depositing the money with a third party like a court or bank. In other words, if the creditor refuses payment without a good reason, the debtor can deposit the payment with a third party. The debtor is then released from their obligation to pay the debt. In short, a refusal without just cause is not equivalent to payment. To have the effect of payment and the consequent extinguishment of the obligation to pay, the law requires the companion acts of tender of payment and consignation. Because refusing payment without a good reason isn't enough to consider the debt paid. To actually pay the debt, the two things are needed. First is tender of payment, offering the payment. Second is consignation, depositing the payment with a third party like a court or bank. Only then is the debt considered paid and the obligation to pay is extinguished. Under these circumstances, the court holds while no completed tender of payment and consignation took place sufficient to constitute payment. The spouses duly established that they have legitimately secured a means of paying off their loan with T Corporation. They were only prevented from doing so by the unjust refusal of S to accept the proceeds of the P Bank loan through her refusal to execute the release of the mortgage on the properties mortgaged to T Corp. In other words, T Corporation and S in fact prevented the spouses from the exercise of the right to secure payment of their loan. No reason exists under this legal situation why the court cannot compel T Corporation and S. First is to release the mortgage to T Corporation as a condition to release of the proceeds of the P Bank loan. Upon P Bank's acknowledgement that the proceeds of the loan are ready and shall forthwith be released, and to accept the proceeds sufficient to cover the total amount of the loan to T as payment for M's loan with T Corporation. To further understand this statement, it simply says that the court says M and N, the spouses, tried to pay their loan to T Corporation using the P Bank loan, but S, the T Corp's president, unfairly refused to accept the payment. The court rules that T Corporation must release the mortgage on the properties, and T Corporation must accept the P Bank loan proceeds as payment for M's loan. In simple terms, the court is saying that T Corporation and S can unfairly block M and M from paying their loan, since M and M have secured a way to pay through the P Bank loan. The court will force T Corporation to release the mortgage and accept the payment. This way, M and N can finally pay their loan and settle their debt with T Corporation. And that is the answer of our problem. And that is all. Thank you for listening, and I hope that you understand every word that I said in this video. Thank you.
Tender of payment may be extrajudicial, while consignation is necessarily judicial, and the priority of the first is the attempt to make a private settlement before proceeding to the solemnities of consignation. Tender of payment. Think of this as the initial attempt by a debtor to pay what they owe. It's like saying, "Here's the money, I'm ready to pay." This can be done privately. Extrajudicial. If the creditor refuses to accept payment, the debtor can then take a more formal legal step called consignation. This usually involves depositing the money, or whatever is owed, with a court of official. It's a judicial process, meaning it requires the court intervention. Problem. It appears from the evidence that X and Y entered into a contract of lease on January 17, 1973, whereby X leased her commercial building and lot to Y for a monthly rental of 800 pesos for a period of 10 years, renewable for another 10 years at the option of the lessee. In view of the alleged non-payment of rental of the leased premises beginning May 1977, X, through her lawyer, sent a letter dated November 23, 1978 to Y, serving notice to the latter to vacate the premises lease. In answer to this letter, Y, through his lawyer, informed X and her lawyer that all payments of rental due her were in fact paid by C Bank through the clerk of court of the City Court of Cebu. Despite this explanation, X filed a case of illegal detainer. The City Court found that there is no showing that the letter allegedly delivered to X in May 1977 contained cash money, check, money order, or any other form of note of value. Hence, there could never be any tender of payment. And even granting that there was, but X refused to accept it without any reason. Still no consignation for May. 1977 rental could be considered in favor of Y unless evidence is presented to establish that he actually made rental deposit with the court in cash money and prior and subsequent to such deposit, he notified X thereof. Was there a valid tender of payment and consignation of the rentals to discharge effectively Y's obligation to pay? Answer: in order that consignation may be effective, the debtor must first comply with certain requirements prescribed by law. The debtor must show, first, that there was a debt due; second, that the consignation of the obligation had been made because of the creditor to whom tender of payment was made refused to accept it, or because he was absent or incapacitated, or because several persons claimed to be entitled to receive the amount due. Third, that previous notice of this consignation had been given to the person interested in the performance of the obligation. Fourth, that the amount due was placed at the disposal of the court. And fifth, that after the consignation had been made, the person interested was notified thereof. Failure in any of these requirements is enough ground to render a consignation ineffective. Without the notice first announced to the persons interested in the fulfillment of the obligation, the consignation as a payment is void. In order to be valid, the tender of payment must be made in lawful currency. While payment in check by the debtor may be acceptable as valid, if no prompt objection to said payment is made, the fact that in previous years payment in check was accepted does not place its creditor in estoppel from requiring the debtor to pay his obligation in cash. The tender of a check to pay for an obligation is not a valid tender of payment thereof. The Supreme Court hold that Y has utterly failed to prove the following requisites of a valid consignation. First, tender of payment of the monthly rentals to the lessor. Second, Y also failed to prove the first notice to the lessor prior to consignation. In this connection, the purpose of the notice is in order to give the creditor an opportunity to reconsider his unjustified refusal and to accept payment, thereby avoiding consignation and the subsequent litigation. Its previous notice is essential to the validity of the consignation and its lack invalidates the same. Third, Y likewise failed to prove the second notice that is after consignation has been made to be lessor. The reason for the notification to the persons interested in the fulfillment of the obligation after consignation had been made, which is separate and distinct from the notification which is made prior to the consignation, is that there should be notice to the creditor prior and after consignation as required by the Civil Code. The reason for this is obvious, namely, to enable the creditor to withdraw the goods or money deposited. Indeed, it would be unjust to make him suffer the risk for any deterioration, depreciation, or loss of such goods or money by reason of lack knowledge of the consignation. And the fourth requisite that Y failed to prove is the actual deposit or consignation of the monthly rentals except the two cashier's checks. The Supreme Court therefore find and ruled that Y has failed to prove tender of payment. He was failed to prove the first notice to the lessor prior to consignation. He was failed to prove the second notice after consignation, and he was failed to pay the rentals for the months of July and August 1977 as of the time the complaint was filed for the eviction of the lessee. The Supreme Court hold that the evidence is clear, competent, and convincing, showing that Y has violated the terms of the lease contract and he may therefore be judicially ejected. Article 1257. In order that the consignation of the thing due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. Problem: spouses H and W executed a contract over their conjugal house and lot in favor of X for and in consideration of 1,310,430 pesos, entitled Deed of Sale under Pacto de Retro. The contract inter alia granted the spouses the option to repurchase the property within 6 months for 1,310,430 pesos plus the agreed interest. Subsequently, W tendered to S the amount of 1,633,034 and 20 centavos in the form of two managers' checks, which the latter refused to accept for being allegedly insufficient. Hence, W filed a complaint for the redemption of the property she deposited with the RTC two checks that X refused to accept. X testified that she incurred expenses including payment of real estate taxes in arrears, transfer tax, and capital gains tax, and other expenses. X admitted, though, that W has tendered payment amounting to 1,633,034.20 in the form of two managers' checks, but these were refused acceptance for being insufficient. She also claimed that several letters were sent to W and her lawyer informing them of the computation of the loan obligation inclusive of said expenses. Was there valid tender of payment and consignation? Answer. Note that the principal loan was 1,310,430 pesos plus 4.5% monthly interest compounded for 6 months. Expressing her desire to pay in the 5th month, W averred that the total amount due was 1,633,034.19 based on the computation of X herself. The amount of 2,911,579.22 that the latter demanded from her to settle the loan obligation was plainly exorbitant, since this sum included other items not covered by the agreement. The property had been used solely as security for the 1,310,430 pesos loan. It therefore improper to include in that amount payments for gasoline and miscellaneous expenses, attorney's fees, and other alleged loans. When X unjustly refused the tender of payment in the amount of 1,633,034.20, W correctly filed suit and consigned the amount in order to be released from the latter's obligation. The two lower courts cited Article 1257 of the Civil Code to justify the ruling that W had failed to notify X of the consignation. This provision of law states that the obligor may be released provided the consignation is first announced to the parties interested in the fulfillment of the obligation. The facts show that the notice requirement was complied with. In her August 1, 1991 letter, W said that should X fail to accept payment, the former would consign the amount. This statement was an unequivocal announcement of consignation, conceitedly sending to the creditor a tender of payment and notice of consignation, which was precisely what W did may be done in the same act. Because W's consignation of the amount of 1,633,034.20 was valid, it produced the effect of payment. The consignation, however, has a retroactive effect, and the payment is deemed to have been made at the time of the deposit of the thing in court or when it was placed at the disposal of the judicial authority. The rationale for consignation is to avoid making the performance of an obligation more onerous to the debtor by reason of causes not imputable to him. Article 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender shall be proved in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. Rationale for consignation. The rationale for consignation is to avoid the performance of an obligation becoming more onerous to the debtor by reason of causes not imputable to him. Article 1259. The expenses of consignation, when properly made, shall be charged against the creditor. The general rule is that the creditor will bear the expenses of consignation because consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it without just cause. Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Effect if consignation has been duly made. The debtor may ask the judge to order the cancellation of the obligation. Hence, it will be the order declaring that consignation has been properly made which will extinguish the obligation. Problem. Pursuant to an agreement and undertaking, X is consideration of the amount of 15,487,500 pesos agreed to sell to Y a lot containing 1,239 square meters. Y paid X the amount of 600,000 pesos as reservation fee and the balance of 887,500 pesos to be paid within 60 days from the execution of the contract, simultaneous with delivery of the owner's duplicate transfer certificate of title, the deed of absolute sale, and the certificate of non-tax delinquency. The parties further agreed that failure on the part of Y to pay the balance of the purchase price entitles X to forfeit the 600,000 pesos option reservation fee while on delivery by the latter of the necessary documents obliges him to return to Y the said reservation fee with interest at 18% per annum. X failed to deliver the required documents in compliance with their agreement. He returned to Y the latter's 600,000 pesos reservation fee by way of check, which was, however, dishonored. What transpired thereafter is disputed by both parties. X claimed that he twice tendered to Y, through his counsel, the amount of 672,900 pesos, representing the 600,000 pesos reservation fee plus 18% interest per annum, in the form of manager's check dated August 3, 1994, but said counsel refused to accept the same. His first attempt to tender payment was allegedly made on August 3, 1994, through his messenger, while the second one was on August 8, 1994, when he sent the manager's check attached to a letter dated August 5, 1994. On August 11, 1994, X wrote a letter to Y saying that he is consigning the amount tendered with the regional trial court on August 15, 1994. X filed a compliant for consignation. Y's counsel, on the other hand, admitted that his office received X letter dated August 5, 1994, but claimed that no check was appended thereto. He averred that there was no valid tender of payment because no check was tendered and the computation of the amount to be tendered was insufficient. Was there a valid consignation? And can X withdraw the amount consigned as a matter of right? Answer: the issues to be resolved in the instant case concerns one of the important requisites of consignation, the existence of a valid tender of payment. As testified by the counsel for Y, the reasons why his client did not accept X tender of payment were: first, the check mentioned in the August 5, 1994 letter of X manifesting that he is settling the obligation was not attached to the said letter, and second, the amount tendered was insufficient to cover the obligation. It is obvious that the reason for Y's non-acceptance of the tender of payment was the alleged insufficiency thereof, and not because the said check was not tendered to Y, or because it was in the form of manager's check. While it is true that in general a manager's check is not legal tender, the creditor has the option of refusing or accepting it. Payment in check by the debtor may be acceptable as valid if no prompt objection to said payment is made. Consequently, X tender of payment in the form of manager's check is valid. The manager's check in the amount of 672,900 pesos, representing the 600,000 pesos reservation fee plus 18% interest per annum, which was tendered but refused by Y, and thereafter consigned with the court, was enough to satisfy the obligation. There being a valid tender of payment in an amount sufficient to extinguish the obligation, the consignation is valid. As regards X's right to withdraw the amount consigned, reliance on Article 1260 of the Civil Code is misplaced. The said article provides, Article 1260, once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation before the creditor has accepted the consignation or before a judicial confirmation that the consignation has been properly made. The debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. The amount consigned with the trial court can no longer be withdrawn by X because Y's prayer in his answer that the amount consigned be awarded to him in equivalent to an acceptance of the consignation, which has the effect of extinguishing X obligation. Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same, he shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. The consignation having made, it means that the creditor has accepted the payment or the court has approved the consignation. Effects if after proper consignation, the debtor withdraws with the authority of the creditor. 1. The obligation remains. 2. The creditor shall lose every preference which he may have over the thing. 3. The co-debtors, guarantors, and sureties shall be released. Example, X owes Y 50,000 pesos due on December 31, 2023. G is the guarantor. On said date, Y refused the payment of X without any valid reason. Subsequently, X consigned the 50,000 pesos in court. Thereafter, X pleaded with Y to withdraw the 50,000 pesos as he needed the said amount to pay hospital bills. Y agreed. What are the legal effects of this withdrawal with the consent of Y? The obligation of X remains. Y shall lose his preference over the 50,000 pesos and G will be released from the obligation to pay 50,000 pesos.
So now let's proceed to section 2, loss of thing 2. So Article 1262 states that an obligation which consists in the delivery of determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor or before he has incurred delay. So when by law or stipulation is something like a contract or agreement, the obligor is liable even for fortuitous event. The loss of thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of obligation requires the assumption of risk. So, how do we understand a thing that is lost? So, first, when it perishes or it goes out of commerce. Second is if it disappears in such a way that its existence is unknown, or when it cannot be recovered. So we have the general rule. The obligation to deliver a determinate thing is extinguished if it should be lost or destroyed. So the general rule says that the obligation to deliver determinate thing is extinguished. So must stop ko ng obligation to deliver a determinate or specific thing kung kani is mawa or maguba. However, Article 1262 provide exception if specific thing is lost. The obligation is not extinguished if first, when the law so provides, second, when the stipulation so provides, third, when the nature of obligation requires the assumption of risk. Later ma-discuss na sa meaning sa, further meaning sa assumption of risk. Then fourth, when the loss of thing occurs with the fault of the debtor, so sa debtor. Five is when the loss of the thing occurs after the debtor has incurred in delay. So, discuss po na later. When the debtor promised to deliver the same thing to two or more persons so who do not have the same interest. Seven, when the obligation is to deliver a generic thing. And lastly, when the obligation to deliver a specific thing arises from a crime. So we have here an example. X promised to deliver to Y a particular bicycle on December 31, 2023, but the said bicycle was lost on December 25, 2023 because of a typhoon. So typhoon is a fortuitous event, so we need to take note that the loss of the bicycle is not in the fault of the debtor, and also it does not incur delay. What majud puts dyan na delay. And according to the exception of Article 1262, the obligation will not be extinguished if it occurs with the fault of the debtor, and fifth, if the thing is lost after the debtor has incurred delay. So, waman si Janing labag ingana nga exception. So, the obligation of X is extinguished. So, we have here a problem. C entrusted his car to D Corp, which is engaged in the sale, distribution, and repair of motor vehicles for the job repair services and supply of parts. D Corp undertook to return the vehicle on July 21, 1990, fully serviced and supplied in accordance with the job contract. After C paid in full the repair bill in the amount of 1,397,000, D Corp issued to him the gate pass for the release of the vehicle on said date. But came July 21, 1990, D Corp could not release the vehicle as its battery was weak and was not yet replaced. Left with no option, C himself bought a new battery nearby and delivered it to D Corp for installation of the same day. However, the battery was not installed and the delivery on the car was rescheduled to July 24, 1990, or 3 days later na. When C sought to reclaim his car in the afternoon of July 24, 1990, he was told that it was carnapped earlier that morning, while being road tested by D Corp's employee. D Corp said that the incident was reported to the police. Having failed to recover his car and its accessories, the value thereof, C filed a suit for damages against D Corp, anchoring his claim on the latter's alleged negligence. For its part, D Corp contended that it was no liability because the car was lost as a result of a fortuitous event. So, question: can a repair shop be held liable for the loss of a customer's vehicle while the same is in his custody for repair of the other job services? So, yes, D Corp will be held liable even if the loss was due to a fortuitous event, because the nature of the obligation requires the assumption of risk. So carnapping is one of that. When you engage to motorcycle shop repairs or car repairs, the assumption of risk, the possibility risk could be carnapping, gadyo na siya. That's why it is required to register to DTI for insurance and policy. And on Article 1262 states that the obligation will not be extinguished if the nature of the obligation requires assumption of risk. And then second is it is already delayed. So ang gimension diri sa exemption is when the loss of the thing occurs after the debtor has incurred in delay. So it's already delayed since the agreement was to return the car on July 21, 1990, and then anong D Corp rescheduled to return the car since so pa kuno na adyo ang battery to July 24, 1990. However, it was carnapped on same morning on July 24, 1990. So yes, D Corp is held liable and that does not extinguish the obligation. So now let's proceed to Article 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So, effect of fortuitous loss in generic obligation. If the obligation is generic in the sense that the object thereof is designated merely by its class or genus without any particular designations or physical segregation from all other of the same class, the loss or destruction of anything of the same kind, even without the debtor's fault, and before he has incurred in delay, will not have the effect of extinguishing the obligation. This rule is based on the principle genus non quam perit, or as what we call the genus never perishes. So we have here an example. X bound himself to give 50 shares to Y. However, all of these were lost through an earthquake. So is X still liable? So the answer is yes, because the object of the obligation is generic thing. So pwede pa si X makuha og laing source para na jay kapuli sa 50 ka shares nga nawa. However, if kanang it is impossible to deliver a thing, it could be converted to a monetary obligation na siya. So, an obligation to pay money is generic, therefore, it is not excuse for fortuitous loss or any specific property of the debtor. So, let's proceed to Article 1264. The court shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. So, Article 1264 says that ang korte ra kuno ang mag-determine or ang magbuot kung ija bang i-extinguish ang obligation or dili. So, we have the general rule. Partial loss of the object of the obligation does not extinguish the obligation. However, there is an exception. When the courts determine that the partial loss of the object of the obligation is so important as to extinguish the obligation, for example, X obliged himself to deliver to Y a motorcycle with a plate number ABC123. Subsequently, its two tires and its engine were lost through a typhoon. In this case, the court shall determine if the loss of the two tires and engine is so important as to extinguish the obligation. So, ang motorcycle ko nawad-an siya og ligid and ang engine. So, kanis siya is partial loss ra ni siya pero kung nahunaon po na to ba, muandar pa di imong motor og wa na kay tire, wa na kay ligid, ug wa na kay engine. So, dili na. So, ang law ijang i-determine that this obligation is now extinguished kay usan ma-consider naman siya nga total loss kay usan pa maligid mo paggamit ang imong motorcycle kung wa na kay ligid og ang engine, di ba? So now let's proceed to Article 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault unless there is a proof to the contrary and without prejudice of the provision of Article 1165. This presumption does not apply in case of earthquake, flood, storm, or other natural calamities. So Article 1265 states that whenever a thing is lost, it is presumed that the debtor is at fault. So it says that it is just presumed, so presumption is not absolute. So how do we overcome the presumption? So first, we need to provide the proofs. So as the general rule says, if the thing is lost while in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to a contrary. So it's the kanang states here in the last sentence, this presumption does not apply in case of earthquake, flood, storm, or other natural calamity. So the presumption of the debtor at fault does not apply if there is the cause of natural calamities. So for the thing to be lost. So here, however, if the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery, regardless of the presence of fault or negligence. So here we have an example. X promised to deliver a specific cell phone to Y on December 31, 2023. Before the said date, the cell phone was lost. This disputable presumption is that the cell phone was lost through the fault of X. However, such presumption will not stand if the cause of the loss was proven that it was due to an earthquake, flood, storm, or other natural calamities. So, ang presumption ani is, nag-expect sila nga ang debtor is the one at fault. However, gi-state diri nga tungod siya sa fortuitous event, so the obligation will be extinguished. So now let's proceed to Article 1266. The debtor in obligation to do shall also be released when the presentation becomes legally or physically impossible without the fault of the obligor. So, let me just clear things up. Loss is not just limited to the loss of things. This also includes the impossibility of a performance. So Article 1266 talks about the effects of loss or impossibility of performance in personal obligation. So impossibility must exist after the constitution of the obligation, because if before, there is really no obligation to speak of. Like, no obligation will be extinguished kung sa una pa lamandaan, imposible na siya nga magkaroon or to have obligation. So, for example, we have X plan to construct a building, a 5-story building. However, a week after, namatay si X. So, there will be a release from his obligation because it is physically impossible, because how can he construct a building kung namatay na siya, 'di ba? So second is we have the, for another example, X, wala po namatay si X. So X is planning to build a 5-story building. in the area. However, the government refuses to issue a building permit because the area is declared by the law to be a residential zone. So the obligation is extinguished because it is legally impossible. So that is what Article 1266 talks about. So now let's proceed to Article 1267. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. So Article 1267 is another exception to the obligation force of a valid and enforceable contract, because when the performance of service has become so difficult as to be manifestly beyond the contemplation of both parties, the court is authorized to release the obligor in whole or in part. So, for example, um, there is a duty to construct a road. However, it so happened that there was an earthquake, so ang earthquake kusog kaadyo, to the point that it changed the condition of land, and such construction was possible but very dangerous to life and properties. So it is something that is not contemplated by both parties to happen. So the debtor can be um, released to the obligation, but one party must ask for relief. So now let's proceed to Article 1268. When the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause of the loss, unless the thing having been offered by him to the person who should receive it, the latter refuse without justification to accept it. So effect if obligation proceeds from a criminal offense. General rule: the debtor shall not be exempted from the payment of the price of the determinate thing, whatever may be caused for the loss. Thus, even if the cause of the loss of the determinate thing is through fortuitous event. So we have here the exception to the rule. The thing having been offered by the debtor to the person who should receive it, the creditor refused without justification to accept it, or the latter refused without justification to accept it. If the creditor is in default, or the mora accipiendi, default in the part of the creditor. So we're gonna have an example for this one later on. So if the thing is a process from a criminal offense, the debtor is liable even if nasjay sa or wala. Even due to fortuitous event, debtor is still liable. We have here example. Mark stole a car for Jane. Excuse me. Kaninga name is just randomly picked. It doesn't base or relate to anybody. So Mark stole Jane's car. So Mark was ordered to return the stolen car to the owner, which is si Jane. But before delivering the car, Mark's house was on fire, including Jane's car. So question, is Mark obligation extinguished? So the answer is no. Mark is still liable and the obligation is not extinguished. Ano naman? Because the obligation to deliver the car arose from a criminal offense. So, as ang mentioned ganina sa Article 1268, when the death of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from payment of its price. So this does not exempt Mark even if the loss was due to a fortuitous event. So what about suppose that Mark already tendered the car to Jane before pa nasunog ang iyang bahay. Yet si Jane ni refused to accept the car. And then the next day nasunog ang bahay ni Mark. So is the obligation extinguished? So the answer is yes. Because of mora accipiende or the fault of the debtor. This is the exemption to the rule. So another example, okay, what if Jane refuses to accept the car? So what should Mark do? Isang bawa na sunog ang bahay ni Jane, but still she refuses to accept the car. So what should Mark do? Mark has options. He could consign these things to the court, or he could keep it in his possession until ma-deliver ni Jane. But first, he need to exercise due diligence of a good father of the family. So now let's proceed to Article 1269. The obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against the third person by the reason of the loss. So the creditor has the right against the third person responsible for the loss. The right of the debtor against the third person is transferred or acquired by the creditor by operation of law by virtue of Article 1269 in order to protect the interest of the creditor. So we have here the example. Mark is obliged to deliver a phone to Jane. However, Paul took the phone, then the phone was later on lost at his fault. So according to Article 1269, Jane has the right to sue Paul. So ano man, when the phone was lost at Paul's fault, Mark's obligation is already extinguished and it's already transferred to Paul. So the Mark's obligation to deliver the phone to Jane is already extinguished. He is no longer liable. So to protect the right of Jane, the law gave her the right as a creditor to proceed against the third person, which is si Paul. So, si Paul nga nakawa sa phone nga supposed to be delivered ni Mark to Jane. So that ends my discussion. Thanks.